In the matter of Chirag Sen and another versus State of Karnataka, Supreme Court allowed the appeals and set aside order of the High Court of Karnataka. Court said that upon careful consideration of the pleadings, documents on record, and rival contentions, we are of the firm view that present case falls within category of exceptional circumstances warranting interference at threshold to prevent abuse of the criminal process. The present appeals arose from a common judgment passed by High Court of Karnataka at Bengaluru, whereby High Court declined to quash criminal proceedings against appellants on allegations relating to falsification of birth records for purpose of securing benefits and selections in age-restricted badminton tournaments. The entire edifice of the complaint was built upon a solitary document, 1996 GPF nomination form, which not only bereft of authentication but also failed to establish fraudulent intent or act attributable to the appellants. The said form does not override birth certificates issued by statutory authorities, nor does it constitute proof of any falsification on part of the appellants. The complainant had neither challenged validity of official birth records before a civil form or offered any explanation as to why alleged discrepancies were not raised contemporaneously. It was evident from material placed on record that allegations were based on conjecture and surmises and were manifestly intended to malign the appellants. No dishonest inducement or gain was demonstrated, nor was there any wrongful loss caused to the state or a third party. Allegations against appellants do not fulfill essential ingredients of sections 420, 468, or 471 of IPC. FIR was registered in 2022. After the same matter was examined and closed by multiple authorities including CVC, which was a premier integrity institution under Government of India. The delay, absence of new material and apparent personal grudge collectively undermines bona fides of complainant. While jurisdiction to quash must be exercised with caution, the law equally mandates that courts must not remain passive in face of manifest injustice. In the case of State of Haryana versus Bhajanlal, Supreme Court recognized that where criminal proceeding is instituted with ulterior motive for wreaking vengeance, court has duty to interdict such abuse. The suggestion that a criminal investigation is necessary to test allegations rings hollow when viewed in light of numerous factual inquiries already conducted by competent authorities. It is relevant to note that issue of age discrepancy had already been examined at the administrative level. The Sports Authority of India on receiving complaints initiated verification process in 2016 which included medical testing and factual inquiries. Players underwent bone ossification and dental examination tests conducted at government run hospitals, including AIMS Delhi. Findings of these tests supported the birth years as recorded in official documents. On that basis, SAI closed the matter. The CVC, an independent oversight body, was also seized of the issue and recommended no disciplinary proceedings against DK Singh. These findings were accepted by relevant authorities and have not been set aside or reopened. While conclusion of administrative bodies was not conclusive for criminal liability, they do bear relevance when evaluating whether complainant discloses prima facie ground to proceed further. The absence of any direct or indirect material linking appellants to culpable act or intention reinforces conclusion that allegations, even if taken at their highest, do not meet threshold necessary to justify criminal prosecution under the provisions. Court had repeatedly cautioned against permitting criminal law to be used as a weapon of harassment. In the case of Pepsi Foods Limited versus Special Judicial Magistrate in 1998, it was held that summoning an accused in a criminal proceeding is a serious matter and should not be undertaken lightly. Appellants were spokespersons of national standing, having represented India at international badminton tournaments and earned multiple accolades, including medals at Commonwealth Games and BWF international events. To compel such individuals who have maintained an unblemished record and brought distinction to the country through sustained excellence to undergo the ordeal of a criminal trial in absence of prima facie material would not subserve the ends of justice. The invocation of criminal law in such circumstances would amount to an abuse of process which the Supreme Court cannot countenance.